Hello everyone, and welcome to this SUMA webinar on the Local Authority Freedom of Information and Protection of Privacy Act, LA FOIP. Thank you all for attending. It's great to have you here today. My name is Steven Dribnenki. I'm going to start with some housekeeping matters. As first, keep an eye out on the Urban Update and member emails for more webinar opportunities. Stay into the end to fill out the survey at the end, and the link to the presentation will be sent out to all registrants in the next few days, as well as a PDF of the PowerPoint. If you take a look at the presentation page, you'll notice there's a chat box for comments and conversation, a Q&A box for questions that will be answered throughout or at the end, and audio instructions if the sound isn't working. Now for today's presenters, Ronald Kruzeniski, QC, Diane Aldridge, and myself, Steven Dribnenki. Ron is Saskatchewan's Information and Privacy Commissioner. He obtained a Bachelor of Administration Law degree from the University of Saskatchewan. He was called to the Saskatchewan Bar in 1973 and was appointed Queen's Counsel in 1984. He was in private practice in Regina for 16 years, during which time he was Chief Commissioner of the Human Rights Commission. He also practiced law in the Ministry of Justice, and in 1995 was appointed to the Public Guardian and Trustee. In 2014, Ron was appointed Information and Privacy Commissioner. Diane is the Director of Compliance for the Office of the Information and Privacy Commissioner. He has spent the last 25 years working for different organizations, including 2 health regions, WCB, and for the last 15 years has been with the Office of the Saskatchewan Information and Privacy Commissioner. She started with the office in March of 2004 as a portfolio officer. She has been Director of Compliance since April 2007, except for a 5-month period when she temporarily took on the Acting Commissioner role. Diane also has a Canadian Institute of Access and Privacy Professional Master's designation. Now, without further ado, let's start the presentation.
Well, welcome and good morning to everybody. Welcome to all of you who have signed in for this webinar. And I want to thank SUMA for arranging it and doing all the organization and getting us up and running this morning. This is what we call a joint presentation. And we kind of like that format at the Commissioner's office for a couple of reasons. Is hopefully by the end of the presentation you've heard what Diane and I have said, but you've also heard what Steven has said. And in 95 to 98% we're going to be in totally agreement. And that's kind of a way of saying to the world, this isn't just our opinion, this isn't just SUMA's opinion, it isn't just Ron or Diane's or Steven's opinion. It's kind of generally accepted, and that's where the state of our law is in the province of Saskatchewan. Steven has introduced us, and what to expect, as I understand it, I'll do the first couple of slides. I'll then pass it over to Diane. Steven will do a number of slides, but you may find that we'll jump in on each other's slides to give a little extra color commentary from time to time. And we certainly rely on Steven because I know there's regional workshops and the SUMA annual convention where you're probably asked, and his telephone, where you're asking him questions about LA FOIP, and we think his importance is pretty relevant. So if we go to the next slide, I'll just briefly outline what Diane mainly will be talking about, or within interjections by Steven and myself. First, I will give a disclaimer and explain that, and then Diane's going to give some basics about LA FOIP and the legislation itself. And I just remind people, this legislation's been there since 1993. Steven will talk a little bit about municipal legislation, and then Diane will talk about access to information, move that into when people request a review from our office. I'll talk about some highlights of reports that were done. We then will go and talk about the privacy and personal information, and that involves the collection of information, the use of information, and the disclosure of information, and the safeguards of information. I sometimes shorten that down to CUD, kind of a good agricultural term to summarize privacy and protection. And then Diane will talk about privacy breaches and investigations. At that point, we'll be into trends and issues and a wrap-up, and we'll flip it back to Steven to manage the questions and answers. So next slide. We always put this in at the beginning. When we assume our educational role, we can't give advanced rulings, but we are trying to tell people what our opinion of the law as it stands today. We can't discuss any cases that are in progress, and if you pick up any of that in the questions, you'll kind of sidestep them, knowing that it's a case in progress. So basically, we're trying to give general information that we think is not in dispute, but if it gets too close to a particular case or giving someone a final ruling on something, we just can't do that today. So I now turn it over to Diane in the next slide.
Thank you, and I see there's been some difficulties in hearing, so I will try to keep my voice as loud as possible. We're talking about the Local Authorities Freedom of Information and Protection of Privacy Act today, but of course that's a mouthful. So what you will hear us continually refer to is LA FOIP, and that's just our acronym or short form that we use. What we find is that even though LA FOIP has been enforced since July 1st, 1993, there's not necessarily a lot of in-depth understanding, and it could be in part because you haven't had to deal with access requests or privacy complaints, and that's okay. But when you get your first one in the door, there's a lot of different details that you have to know because there are timelines that have to be taken into consideration. So hopefully today we're going to scratch the surface, point you in the right direction, and make you feel a little bit more familiar with the legislation. There were some significant amendments January 1st, 2018. We don't have time to get into many of those. I will touch on a few. We do have a webinar on our website that goes into a greater depth in terms of the amendments. So if you're interested in those, please take a look at our website, www.oipc.sk.ca. So in short, what is LA FOIP about? Well, it sets out some rules, responsibilities, and rights. And the first is the right to access information, which I'll go into a lot greater detail. It's access to the records in the possession or under the control of a local authority, which of course municipalities are. There are limited and specific reasons in which the information can be withheld, but the default really is to provide access if one of those limited or specific reasons do not exist. There also is a right of correction or amendment if personal information is inaccurate or some key information is missing. But there are also rules around collection, use, and disclosure of personal information so that we know when it is appropriate and not appropriate to share that information. LA FOIP also provides a right to complain to the commissioner, and I will go into greater detail as to when that occurs. Next slide.
Now with that, this is just to remind people, if they don't know, and to let people know if they don't know, just that there is also various duties, not only in the LA FOIP, but listed in municipal legislation. What goes to the way that you handle information in particular and what matters are private. Now, the key thing to keep in mind that while there will be sections listed in the acts that are set up there, the Cities Act, Municipalities Act, and the Municipalities Act, there's also LA FOIP, which essentially calls the shot. It's a general legal principle that legislation that has a general nature gives way to specific legislation on a subject. So for example, Legislations Act has a general requirement of starting a claim within 2 years, but for municipalities it's different. It specifically says in the Municipalities Act, for instance, that it's limited to 1 year. Now, while in most aspects LA FOIP and municipal acts can be read in tandem without any issue and are quite supportive of each other, at times confusion can result. One of those things that may give rise confusion, is the first point listed on the slide, that administrators and clerks are in charge of safekeeping of municipal documents. However, when you look at LA FOIP, the mayors are to respond to access to information requests. That being said, you can delegate that authority, and I strongly recommend that you do delegate it. So in general, as well, when it comes to administrators, the documents that they're in charge of, they have the oversight role, and counselors who are should not be in the practice of accessing information, and generally should be turning over information over to the administrator. And there's a lot of great resources on the Office of the Privacy Commissioner's website on counselor duties in a document entitled "What Counselors Should Know About LA FOIP." I also would like to turn your mind and attention to the last 2 points there. One about certain documents that must be kept public, and that's minutes, financial statements, and contracts approved by council. It's important to keep that in mind. These are fundamental to government's issues, and ensuring that the residents have key information that's relevant to the democratic process. And the default should be how you can make this information readily available to the public at the least amount of cost for their access. The next point I would also just like to make quickly is that when it comes to private meetings, and we'll be getting into this a little bit more, there's only certain matters that you can call a meeting for in camera or to discuss private matters, and that those are exemptions are listed in LA FOIP, such things as like solicitor-client privilege and third-party business interests. And the Office of the Privacy Commissioner also has a great resource entitled Guide to Exemptions, which I suggest you check out if you're looking for more information on that.
Great, thanks, Steven. So next we're going to talk more specifically about access to information, which is one of the twin themes. If you think about a coin, access to information is one side, privacy is the flip side. So I'm really trying to keep the presentation focused on the two major parts. So access to information is that right of the individual, and we call that individual an applicant. The applicant makes an access request to the local authority, to the municipality, and what they're looking for is access to records, to source documents. And the reason behind access and privacy legislation, at least the access side of things, is to keep governments, either local governments, provincial governments, other public bodies, accountable to the taxpayer, because these organizations are funded by the taxpayer. So of course the taxpayer has a vested interest in terms of how their tax dollars are being used. So when an access request is made to that public body, then those obligations kick in terms of what has to be provided. And it's copies of source documents. And that's really important because then the information itself can't be spun. You actually get to see what decisions were made, how you got there, and you can question if you are an individual and you're not sure that you really think it was the right decision. So if the applicant contacts your organization and they want something different, maybe they only want a summary or they want it condensed or some sort of a secondary document, that's perfectly okay as long as you are working with them and negotiating. However, you can't just assume that's what they want and provide because, again, it's that right to source documents. And what are we dealing with here? It's records. It's information in any recorded form or format, which may surprise you. That could turn out to be a video recording. It could be a text message. It could be a Word document. It could be emails. The list goes on. And so really looking at how do we conduct ourselves when we're doing business? And are we making sure that we're maintaining the records that are required in order to do that? And the records are in possession or control of the municipality. And what does that mean? Possession is something that you can touch. It's tangible. It's a paper document. It's something you wrote down. It's something you've entered into a database. Again, maybe that text message, but it's physically within your grasp. But you also have to have what we call a measure of control. An example of a privacy breach is if a doctor's office goes to fax a patient's information to the lab, gets the fax number wrong, and instead sends it to a media outlet. Well, that would be a privacy breach, and the media outlet doesn't have a right to possess that record, so shouldn't have it. The broader control is the right to manage. So, for instance, if I have a contractor, I should have a strong contract, a written agreement, so that the contractor is only providing those services on my behalf, and if it contains personal information of my clients, customers, or citizens, that I know at the end of the day that if we terminate that contract, that information will be returned or destroyed. Because I, as the public body, it's my role to ensure that that information is only used for the municipality's purposes, not for the contractor's purposes. The other thing you're going to see quite often if media, for instance, makes access to information requests is that they often will have questions. And there's no obligation under LA FOIP to answer questions. However, if there are records that speak specifically to that information that they're seeking, then by all means, that could be responsive records that you would want to produce. The other thing is, when we look at records management, and it's taking into consideration all those different forms or formats, is if you've kept it, it is potentially responsive to an access request. So if you have records from 60 years ago, 80 years ago, and someone asks for it, you may have to make that available. An example of where there was a challenge with it, again, a health authority, they had an access request for records from the 1960s that were only available on microfiche. Their microfiche reader didn't work, but it was a record that was in their possession and control, and they had to produce it. So they got a little creative, borrowed somebody else's equipment, and made it available. Next slide, please. So for processing the request, the application comes in the front door, and there should be two things there. One, the application itself, and you know, we'll get into this a little bit further on, is on the prescribed form, which you'll find in the regulations, or it can be in writing as long as it has those necessary elements. There is a $20 application fee that should come with that, but once that application is received, then the clock starts ticking. The organization only has 30 calendar days, not business days, in order to process that request and to turn around, provide what we call a Section 7 response, which I'll show you a sample of in a few minutes, and to either release the records, withhold, or do other things, which I'll talk about in a bit. But within that 30 days, it's, well, how do we find what those responsive records are? We need a search strategy. Where do we look? What type of information are we talking about? Do I have to consult with other people within the organization? And what really helps is needing that duty to assist under the legislation. It's Section 5.1, which is responding openly, accurately, and completely to the applicant. And the best way to do that is to have a conversation, you know, have email correspondence. Try to focus what it is exactly would satisfy that applicant. And if in fact you can do that, you're less likely going to have a problem down the road and our office being engaged. You have to determine if a fee estimate is warranted. There's a lot that go into fees, but you know, at the heart of it, it's, you know, how much time it's going to take to search for these records, to prep them, which is, in terms of compensable fees, we're looking at severing, which is taking out, masking what you can't provide, and then reproduction costs. Again, we don't have a lot of time to go into that. Also, if you're going through the records line by line and determining what can and cannot be released, it's really important to look for third-party information. And that's either third-party business information under Section 18, or what we're looking at is third-party personal information. And if so you're finding it, you need to provide third-party notice under the Act. And that actually takes some time, so you may also have to do a time extension. You can extend up to a maximum of 60 days, but everything must be resolved within that time period, and you have to provide that notice to the applicant. And finally, when you're applying what we call exemptions, which will be the next slide, it's really looking at what can and cannot be released. So next slide. So reasons to withhold. The primary reasons are found in Part 3 of LA FOIP. These are exemptions, and they're either mandatory, these are the shall, you'll actually see that wording in the exemption itself, or may, these are the discretionary ones. Stephen already gave some examples of some of these, including if it's social-crime privilege material, advice from officials, you have a lawful investigation or a law enforcement investigation underway, it would harm economic interests, trade secrets, the list goes on and on. So it's really important to become familiar with these. But there are other reasons in which you may withhold or point to another source and release. And these are exclusions. Some examples of it's a matter of public records, it's published material, or it's available for purchase. So an example that comes to mind is a public registry, or for instance, getting the information from ISD. Or another act prevails. Steven mentioned, of course, that generally when we're dealing with LA FOIP, it takes the lead. It trumps other legislation, but not always. And so you have to look specifically at the Act at 23 sub 3 or in the regulations 8.1, and it says which specific laws or sections of laws actually will trump instead. And so it's becoming familiar where those exceptions lie. And lastly, that the documents themselves will be published within 90 days. So rather than going to all the efforts of trying to determine what may or may not need to be severed, it's letting the applicant know that no, this will be available on our website or in another location within 90 days, so you just need to wait a little bit longer. Next slide. So there's a lot about what can be withheld, but also what can be released. The mandatory exceptions, they're the shall, that material needs to be withheld. But there are some cases where that isn't the case. And an example, I'm skipping down a couple of my bullet points, but if, for instance, you had the consent of a third party, for instance, sometimes they don't care. They'll receive notification from the public body that this is third party material that they have. But if the third party doesn't care and they actually consent to the release, then that would trigger your ability as a public body to release that information. On the discretionary side, when we're looking at exemptions, it's not just exemptions, it's also if there's third-party personal information. The exercise of discretion comes into play after you've demonstrated that the exemption does apply. So for instance, advice from officials, you've determined this is consultations or deliberations, but you ask yourself the question, what would be the harm in releasing this anyway? And if you determine there isn't harm, then you may exercise that discretion and release. There are other public interest overrides as well. When you look at it on a privacy side, privacy is a right, but no rights are absolute. And sometimes the public interest will prevail, it will override. And so there's that balancing act, and sometimes the decision is made to release the information publicly nonetheless. Some other examples of public interest override that deals with other kinds of confidential information is if, for instance, there would be some sort of public health, public safety, or protection of the environment issue. And so if that is found in a number of cases, and these are right in Part 3 of LA FOIP, so there's guidance there in terms of when you need to make that call, but it really is your call, and it's important to document when those decisions are made. Also, if information is sufficiently de-identified, is statistical or aggregate data, then if it originally was personal information, the privacy interests are gone. So in those cases, you should feel safe in releasing that data. And often, media, journalists, they're interested in stats, right? That's what they're going to write their story on. If information is otherwise publicly available, you can point to a source instead of having to go through a process of request. And then, as already alluded to too, there are other laws that require or permit disclosure, and so you should follow with what those specific rules are. An example, the Cities Act in subsection 91, sub 1, any person is entitled at any time during regular business hours to inspect and obtain copies of A, any contract approved by the council, any bylaws or resolutions, and any account paid by the council relating to the city. So there's a perfect example of information that should be made available. Next slide. So the 30 days has gone by, you've done all that hard work, or the 60 days, you've heard back from your third parties. How do you respond to the applicant? And I know that can be a little overwhelming if you haven't done it before, but luckily there are templates available. What you'll see up on the screen is one such template. It is available at the link that I've provided on the screen, as well as there's a separate link on our website. It's the Access and Privacy branch of the Ministry of Justice that has provided these templates. And there's a different template for a different type of response. So in some cases, if you're denying access in full, it might look one way. If you're denying access in part, another. You're responding and providing a fee estimate. Or maybe you're not going to confirm or deny the existence of a record. But one of the paragraphs that will be provided in every template is the right for the individual to request a review if they're dissatisfied with your decision-making of the commissioner. And that should be standard in every template letter. And then, of course, it's our role, which I'll talk about in a minute, to let you know why we're undertaking a review. Okay, next slide. So this next slide is one of those ways in which individuals, in this case the applicant, can make a complaint to our office, the Office of the Information and Privacy Commissioner, or the IPC. So what happens? You provided that Section 7 response. The applicant is not happy. They request a review of our office. And generally it's because access is denied, but it can be for other reasons, as I already mentioned. Then what we do is we have early resolution officers that will work with the parties to see if the matter can be resolved at that stage without going forward in a formal way. If it does, a file number will be assigned, and you will either get a letter or an email, most likely an email from us, that will say, well, this is specifically what the concerns were, we outlined the scope, our jurisdiction, and then we give you some timeline. And we know it can be challenging because everything is a clock that's ticking. We ask that you provide a response to us, a copy of the responsive records that were withheld in full or in part, and your submission or your arguments as to why you can withhold the information within 14 calendar days. And I know that's a really tight turnaround time. So we are open to extensions. There will be an analyst who will be assigned the file. Their name will be listed in the email. All you have to do is to contact them and negotiate in terms of how much more time you may need in the circumstances. Once we get everything, we've heard from the parties, the analyst does an assessment. If it's necessary, we'll draft a report that will come out only to the municipality. We want to hear from you in terms of facts, if everything is, we got it right. And then what happens usually in about 7 days is we will come up with the final report, issue it, and that will go and be available on our website. And all the parties, including a third party who is involved, will get a copy of that report. Next slide.
Oh, it's my turn to talk about a couple specific examples. Diane referred to final reports, and on this slide we've listed 4 reports. And now Steven talked me into doing an article for the Urban Voice, and it just was sent out the last week or two, Steven?
Yes.
Yeah. So you can see the summary of these cases in the article. Alternatively, you can go to our website and type in the file number of the case, or for example, the first one, the Rural Municipality of Blaine Lake, and you will get the cases pertaining to Blaine Lake. The first report that I want to talk about does involve the RM of Blaine Lake, and an applicant sent in the letter kind of requesting information but raising a concern about an ongoing privacy concern. When it got to our office, we looked at the letter that the applicant had forwarded and concluded it didn't constitute an access request as required by Section 6 of the Act. But we did conclude that there was a possible privacy breach, and we converted the investigation into an investigation of that privacy breach. Now, the important thing, an applicant, if they do things perfectly, should have certain elements in their access request. But we have 1 million citizens in the province, and they are not always aware of exactly what should be in the request. In this case, the RM kind of said it wasn't an access request. I would encourage parties to take a second look. If it's missing a point, it's probably a matter of an email or a phone call to ask the person, what exactly were you asking for? And basically turn it into an access request. Because in the case of once deciding that it wasn't an access request, the applicant could have turned around and said, okay, I give you a bit more information, here's my access request. So one isn't really winning the battle, they're just postponing it. So I would encourage parties to take a liberal approach to when they get a letter and it's missing a couple of things, to pick up the phone and fill in the blanks, so to speak. The second case is the town of Tisdale, and there the complaint was that the town didn't do an adequate search. And our conclusion when we reviewed it was that the town did do an adequate search, and therefore nothing more was being recommended. In that report, it would certainly outline what we think is an adequate or reasonable search. And it really is important for administrators to have a sense that when they get an access request, and first of all, step one is, if there's a lack of clarity, contact the applicant to see if you can define exactly what the person is wanting. But then when you go and do your search, that you do it in a systematic way. We call it developing a bit of a search strategy. And in fact, it was the Ministry of Environment that has developed what they call a search log. And it's basically a one-pager, a checklist where you can check off the things that you've done when you're doing the search. Now you might say, kind of bureaucratic. Yes, it is. But remember, an applicant potentially 10 or 11 months later may complain to our office that you didn't do a good search. And how are you going to remember what was done 11 months ago or 12 months ago? So by having this little checklist and say, well, I did this, I searched the file drawers, and I searched the computer server, I used these as a keyword, is on your file, and you can then respond and say, well, here, Information and Privacy Commissioner, here's the search we did. So that's just a little bit about searches. The next report is, again, the RM of Blaine Lake, and the applicant submitted a request, and the RM sent a letter quoting a fee. Now, everyone is entitled to issue a fee estimate. In the regulations, there is local authorities are entitled for an initial application fee of $20. But over and above that, they can look at what they have to do and the reproduction costs and issue a fee estimate. I like to think that if the fee estimate is under $100, really, as a taxpayer, shouldn't the person get the information without a fee? But on the other hand, if it's a tremendous amount of work, one needs to do and one, based on policy of the council or the size and scope, there is the entitlement to do a fee estimate. In this particular case, our office concluded that the fee for preparing the documents for disclosure wasn't exactly right. We suggested a reduction, but the fee regarding photocopying was an appropriate portion of the fee. So in that case, and I know later on Steven's going to talk about photocopying costs when it gets to his next slide. The last case is the RM of Manitou Lake. And this involved a request for records. The applicant felt an adequate search had not been made. We investigated it, concluded that the search had not been extensive enough. But really, the reason I put the case in the article and talk about it today is the whole issue of counselor records. I'm thinking, and I'm hoping Steven comments about this when he gets a chance, or right after me if he wishes. Basically, our approach is that communications with the counselor regarding business of the local authority are part of the records that should be disclosed. And that would involve, if the counselor uses his or her personal email, and that from time to time you're going to have to ask the counselor to sort through it and say, I've got an access request, and it involves some of your records. Go through your 5,000 emails and pull out the ones that relate to X, whatever the business issue is. I think there's an initial reaction is, this is my personal email, nobody else's business. But it's municipal business that we're talking about. So there are some things that we've recommended people do. And one of them is local authorities and government authorities should encourage those people that sit on boards or councils or whatever to have a separate email account. Call it a business account. If the person's in business, then I guess you have to call it a municipal account. And that's the one that the administrators then would send agendas to or minutes to the counselor's municipal account. Now, there's one relatively easy way, and again, I hope, I think Steven has talked about this in the past. If you have a website, it's quite easy then to set up municipal email addresses, including mayors and councillors. And that starts the segregation of keeping the business matters of council in that particular account and the personal matters like bring home a loaf of bread in a totally different account. Steven, that's the end of my cases. Do you want to comment on this one now or later?
Oh, I'll go into it a little bit later, but great points.
Back to Diane.
All right, next slide. Now, some would argue this next part of our presentation is the more interesting portion because we're talking about privacy. And what does that really mean? What's interesting is privacy is not defined by any privacy law anywhere. And what does it mean? It's something that's very personal to individuals. It's an ever-evolving concept. One of my favorite definitions is the right to be left or left alone. There are different dimensions of privacy, bodily, territorial, and privacy of communication, but really we're focusing in on one form, which is the next slide. So we're specifically talking about informational or data privacy, and what does that mean? It's the right of the individual, the person, the data subject, to determine for him or herself when, how, and to what extent he or she will share, or an organization will share that personal information. And personal information is our focus, and the rules are around what do we do with personal information as a local authority. It's generally about an identifiable individual, but it also has to be personal in nature. But what helps is that it is defined by LA FOIP in subsection 23 sub 1. What is not personal information is captured by 23 sub 2, but these are examples. One of the types of personal information that I find is generally misunderstood the most is somebody's opinion about another person. So if I said, let's say in an email, that I think Steven is a fabulous person, that is actually his personal opinion, not mine. I'm the author, but it's about him, so it constitutes his personal information.
But if you say Steven is who owns that?
And this is why it's so important to write objective, not subjective comments in our professional correspondence. Next slide. As I mentioned earlier, it's not personal information. It's sufficiently de-identified, statistical, or aggregate. But you have to keep aware of what are unique identifiers. So right now, sitting in this room, I could point out a number of specific data elements about male or female, age, different things like that. We may not have an identifiable individual, but the second I say I'm sitting with the Information and Privacy Commissioner, everybody knows in the province who I'm talking about. But would that in itself be the Commissioner's personal information? I would say no, because it's business card information. The fact that any one of us work for any particular organization, that's not really about us. It's about the job itself. And so what I do, how I do it, the work that I produce is work product, not personal. And so that type of information doesn't attract a privacy interest. However, if I am being evaluated by my boss and my boss critiques me, that is my employment history and is personal information. So would have to be sufficiently protected. The next slide. Some other key terms, confidentiality. We hear about it all the time, and I find often there is some confusion as to when it is confidentiality dealing with personal information and private interests, or is it about proprietary information or third-party protected information like trade secrets. So the kind of confidentiality we're dealing with here is the protection of that personal information. And it's that duty or obligation on me if I'm working for the municipality. And it's really about a trust relationship, because if the individual doesn't trust me, well, they may not tell me anything I need to know, or they may lie. And so it's developing that trust relationship so that they will share and that you're able to, provide the services that that individual needs. So then security, that's how we protect that information. It's looking at a threat risk assessment, determining specifically, how might this information become vulnerable, and putting in safeguards or controls to protect that information. But I will come back to safeguards in a couple of slides. My favorite slide. It's a cow. Yes, it's a cow. I'm a farm girl, so I have to sneak these into presentations wherever I can. And it says, what's cud got to do with it? Well, the Commissioner already mentioned collection use disclosure, cows chew their cud. Forevermore, this should be burned into your brain. So collection is simply you are bringing the information into the municipality in some form. You're collecting it, you're receiving it, you're obtaining it, you're gathering it, and ultimately it gets recorded somewhere, because personal information under LA FOIP also must be in recorded form. Does that mean you can't have a privacy breach if you share it verbally? Of course you can, as long as it ties back to information recorded within your possession or your control. Use is what you do with that personal information internally, and disclosure is sharing it with someone outside of the organization itself so that you lose that control of the information. And these are all called data transactions, and LA FOIP is clear in terms of when you can and cannot collect, use, or disclose. But one of the common themes is a privacy principle that you must adhere to what we call the data minimization principle, which is only taking in, using, and sharing the least amount of personal information necessary for your purposes. So if you need 5 data elements, you collect 5. You don't collect 6, because that's where a privacy breach may occur. Next slide. So back to safeguards. It's looking at all those controls, how do we protect the data. 3 primary types: physical, administrative, and technical. Administrative are also your operational ones, like your policies, procedures, training, supervision, oaths of confidentiality. Physical are the obvious ones: locked doors, locked filing cabinets. Technical, strong passwords, making sure that you have the appropriate firewalls and what have you. And it's a layered approach, because you can't just say, oh, we lock our doors so everything's secure. you may need to make sure to safeguard that information that you're looking at every possible angle. And again, that's why the threat risk assessments are important. But it's also looking at the life cycle of the information. So you need to protect it from collection right to safe destruction. We've had, unfortunately, too many privacy breaches where the wind has taken some of the personal information that's blown off the back of trucks, or address-graph cards we found that were just strewn across a parking lot, or even information that was found in a recycling bin. Everybody may be familiar with that investigation that took place in 2011.
We also had one where certain information was found in the floor of a chicken coop.
Mm-hmm. Yes, not a good way to dispose of your sensitive records. Another farm example. So the next slide is about what happens if there is a privacy breach. So for instance, you decided to line your chicken coop with personal information. What do you do as an organization? Because maybe we contacted you and we started our formal process, or maybe you learned of a privacy breach on your own. So for instance, maybe it was a fax that went to the wrong place. Maybe it was employee snooping. There's a variety of ways in which you could end up with a privacy breach. The first step is to contain. So if the email was sent to the wrong recipient, contacting the other recipient, maybe getting your IT department involved, and making sure that the copy isn't retained, they're not sharing that information, they're not printing it, and that ultimately you don't have to worry about the breach getting broader and bigger. Second, investigate. Do a root cause analysis. Why did this happen in the first place? We hear all the time, oh, it's human error. But it's only human error if, in fact, you didn't do your due diligence and train people, have work standards, explain to people, this is the safe way in which to send a fax or an email. Doing the assessing and the analyzing is very important as well as part of that whole process. And part of that is the risk to the individual. So maybe what was breached and was sent by email to the wrong person was a citizen's address. Well, maybe the risk isn't so great to the person, but maybe it was their social insurance number. Maybe it was medical diagnosis. It could be a whole variety of different data elements that were included, and the data subject is going to care about what was involved and what they can do to protect themselves. Notification is contacting that affected individual, and we call them affected individuals, not victims, because they may or may not become a victim down the road of identity theft or something else. There are actual now requirements in the Act to provide mandatory breach notification to affected individuals under Section 28.1 if you have determined that you believe the incident creates a real risk of significant harm to the individual. There isn't mandatory reporting to our office. However, we often find that if the municipality or any local authority does provide proactive breach reporting to our office, that we most likely will not issue a public report. The last step is prevention. So you've done your root cause analysis, you've figured out why this happened in the first place. What are you going to do differently to help prevent this from ever happening again? And sometimes it's as simple as putting in some steps that individuals need to follow before, for instance, sending that email, like verifying that it actually is an email that's valid. The next slide. So if our office does do an investigation, I mentioned already the proactively reported ones, but also if we're doing our own investigation because we have a complainant, the affected individual could be a complainant, comes to our office. In both cases, we want to see an investigation report. Luckily, we have some templates, some guidance documents on our website again that you can use to really focus your thoughts and to get us the information that we need in order to determine if we're satisfied or not. If we are satisfied, we may not go to a public report. However, if we do, it's the same process as with a review report where there's a draft that's sent out, same timelines, and then ends in a final report that'll be posted on our website.
Great, thank you very much, Diane. And this slide, I'll speak to it, and it's essentially just some hot takes, sort of a rapid-fire responses on a couple of questions that I've seen in my time, either directly asked or or issues that I've seen emerge from various either news stories or documents or trends and issues that arise. First question of who's in charge, and you know, any given day, any given Monday, I guess I'll say, the administrator will be in charge of all the documents, keeping them safe. However, under LA FOIP, the mayor is responsible to respond to information requests. However, that's a duty that can be delegated, and I strongly recommend, I will underline that, I will italicize that, and I will bold it, strongly recommend that you delegate it to the administrator. There are technical requirements when developing a response, and any mayor who I've spoken to had to go through that has realized it's quite difficult, and honestly, they won't know what much is because, again, the administrator is responsible for day-to-day document safekeeping. On top of that, LA FOIP has a lot of duties and necessary duties about the duty to protect. There's prohibitions on snooping, and you, of course, want to not have any inadvertent leaks. So there's a lot of risk and little reward. So keep that in mind if you need to delegate that responsibility. The second point is what can I charge? And these are beyond the application fees. Of course, LA FOIP regulations will set out charges at Section 5 of the regulations, and that includes application fees and photocopy fees and all that sort of stuff. However, Municipalities Act, Section 117, as the rest of the municipal acts, states something along the lines of reasonable fees might be charged for accessing normally publicly accessible documents. And so I would suggest, as a rule of thumb, if you are going to charge something, follow the LA FOIP regulations as close as you can. I do note that the provincial court fees regulations have been updated. That, of course, does not apply to you, but at the same time, too, just as a little note, it looks like it costs them $1 per photocopy page. However, let's leave that there. I guess they just have very expensive photocopiers at the provincial courts. But that being said, 25 cents is typically the going rate and what people might expect. But that being said, other municipalities I've spoken with take the approach that this is fundamental documentation that should be available. And for instance, I'd say consider Hansard debates. How much does it cost to access those? It doesn't cost anything. It's on the Saskatchewan legislature. It's on the Parliament of Canada legislature, Parliament of Canada websites. You can get them, and it's a fundamental democratic issue to understand what the government is up to. And so my suggestion is make the basic key stuff readily available at the lowest public cost. Get a website and post minutes and key bylaws and financial statements on it. All the stuff that you would usually have readily send out no matter what. These are publicly accessible and keeps it easy. Last point is who owns it. Just be very aware. It's been discussed on a couple of points. Email accounts. If you're using your personal email account, if there's any way you cannot do that anymore and perhaps move to another municipal focused account, that's a great practice. It's the best practice. It's another good reason to get a website, so you have that yourtown.ca or whatever as the end, and everybody understands that that's the municipal website. And just as a last point as well, if you're working on a municipal cell phone or a municipally owned electronic device, it is owned by the municipality. And so keep as best you can personal information off it. And lastly, get a policy in place and follow it closely. Back to you, Diane.
So to wrap up, the first point I have is adhere to the data minimization and need to know principle. The need to know I didn't get into, but really quickly. It's pretty simple when you look at collection, use, and disclosure. If you need to get access to personal information, those 5 data elements, in order to do your job, then you have a need to know. If you don't, and it's just nice to know, then it might be a privacy breach. So always think about what do I absolutely need to look at, to share with others when it comes to doing my job. And when in doubt, ask. If you have a privacy officer, talk to somebody who is, your internal expert or the head, and come up with some policies and procedures again to keep you focused on that. Really think about the information.
And Diane, if all those fail, you can always call Steven.
That's right.
Steven?
He's available. I'm sure 24/7.
Yeah.
Information lifecycle management is so important because, again, it's thinking about the information from collection to destruction, and how long do we need to keep this information? Because if you keep the information from 1960, remember, you may have to make that available within 30 calendar days. Confidentiality undertakings or pledges are so important because what we often find is employees will say, well, I didn't know I couldn't do that. So if you have some really granular language within these agreements, they can't then say, oops, I didn't know. We do have a sample of one of those agreements on our website. Get it in writing, have contracts, agreements, policies, and procedures. Because again, then it's harder for people to say, I didn't know that those are the rules to follow. Make sure it's accurate and complete, especially with personal information. It's hard to provide accurate, helpful services to citizens if you don't have their address correct. Train, and train some more. We actually make a recommendation that you should be providing annual privacy training because we do need refreshers. And there are changes to legislation that people need to be aware of. Restrict, suspend, or disable user accounts when individuals are on leave or change roles or are terminated. Unfortunately, sometimes people have remote access. And if you haven't shut that down, they could be snooping off-site, off-work hours. Monitor and audit your electronic systems as much as you can. If they don't have that kind of logging capabilities, maybe it's something to look into when you're looking at implementing new technologies. And again, secure destruction, cross-shredding is a perfect example of that. Witness shreds, actually going with the company and observing them shred those documents. There's nothing left, incinerating, but not necessarily having a bonfire in your backyard because flames can go out, records can blow away. Next slide. I know we want to spend some time on questions and answers, so I'm not going to go through all of these resources, but everything on this particular slide is available on our website. And if you're having difficulties finding any of them, just give us a call and we'll help direct you to them. So hopefully we can take some questions now.
Absolutely. Thank you very much, Diane. Thank you very much, Ron, as well. It was very informative. It was very interesting in an area that sometimes can be quite confusing. But I think that there's a roadmap here that's been placed out. There is some time for questions, and we'll probably run a minute or two over just to make sure that we can get a few questions in. That being said, I'm going to take a brief moment just to provide a short summary while people type in their questions in the Q&A box. And biggest thing I just want to go back to is just to encourage everyone to access the information that is available. Of course, there is the Privacy Commissioner website. There's a lot of great resources on there. The Ministry of Justice Access and Privacy Branch has resources. The Government of Saskatchewan website under Municipal Administration has also great resources. And then there's also resources provided by SUMA. Most significantly, as mentioned by Ron, there's a great article from the office that in our most recent issue of Urban Voice. Also, feel free to pick up the phone and chat with somebody from the Office of the Privacy Commissioner, and they quite often help you. And if there's questions you might have, or if you'd rather just bounce some ideas off me, feel free. Please call me or email me, and I'll help best I can and try to get you linked up with the information that might help you.
Right, and just to let you know, if you contact our office, it's confidential, and I won't judge you.
And Steven provides a 24/7 service. Oh, it really excites me.
Well, it's more of a 40-hour-a-week service. We're available now. I do take a vacation once in a while too. But all that being said, let's get to the questions here. First question: this $20 fee applies to any application for any form of information? Question mark. So I'll throw that over to you, Diane, if you want to have first thoughts on that. Or...
You bet. If it's an access information request under LA FOIP, you bet there's a $20 application fee. It may be waived, however. Often when you think about it, if a person's making an access request for their personal information, or if you just don't feel it's necessary, that's always within your power to say no, thank you.
And if I could just add to that, there was one report where that $20 fee was being charged to a counselor. And frankly, I thought that was just wrong because a counselor, in order to do his or her work, needs information. And, I guess there can be sometimes councillors who create a little more controversy, but they're still a councillor, they're still elected. And I really, as an opinion, don't think they should be being charged a fee. Any thoughts on that one, Steve?
I think you make some good points. It's, of course, I think municipalities should have a policy. They should be thinking about this proactively. They should be understanding, because these can be very, very thorny issues once they go up, and you want to make sure that everybody can still work around the council table at the end of the day, and ensure that the councillors can carry out their duties. And let's go to the next question. There was a request from a property owner for a copy of a survey or surveyor certificate for a property. The survey was done by a third party, and this was contracted. It was not done by the municipality. Is the municipality able to provide a copy to the requester?
Right, and it sounds like this gets back to my comments about possession or control. So if you have a physical copy of it, or the contractor was someone who you had contracted with, and it should have spelled out in the contract itself that these are your records that you have a right to manage. If not, that might create a little bit of friction with the contractor. However, it sounds like it should be in your possession control and should be made available upon an access request, as long as, again, there wasn't some exemption that you would apply in a circumstance.
Great. Let's go to the next question then. If a municipality prints an email, are they allowed then to delete the email from the computer?
This is always such a fun topic. When we look at on the records management side is what are those record management obligations? And Steve, I think you had spoken a little bit in terms of the preservation of certain documents. But really it's making sure that you have that official record. If there's a duplicate, it's often referred to as what we call a transitory record. So as long as there is that official copy that is maintained, you may not need the second copy of it.
It strikes me local authorities and every organization in the province has to make a fundamental decision, and that is where do you decide that your official records are going to be? Are they going to be on paper or are they going to be electronic? If your official record is paper, you can delete the electronic email. If your official record is electronic, you can destroy the paper. Now, what I think we're all wrestling with in this province is we really shifted from paper to databases. Many organizations, large and small, have computers that store their stuff. So it strikes me 5 years from now, I would not be making the distinction between paper and electronic, that most of us are going to save stuff electronically. So you need to keep that in mind. Where are you on this continuum from shifting from paper to electronic? And one of the worst positions to be in is when you're doing both, because then which one is your official record? So kind of a fundamental policy I don't think it would qualify as a bylaw, Stephen, but in your retention policy, one of your first statements should be, our official records are saved in paper or on the server.
Yes, absolutely. Great points. I think that I recall from my time in private practice as well, there was always discussion about best evidence and where would it be best to have it, what's the original thing. And so there's an element of that which, doesn't really specifically go to what sort of legal duty might be in place. But, however, what is best practice? What's the best way that it'll help you manage your office in the best way, safeguard items in the best way? And so that should be set out in a policy. Also, when you print out that email, is it going somewhere else? And maybe is it being sent out as part of some sort of thing? And so what if it gets deleted and all of a sudden that's the end of it because you just sent it out? Just keep those things in mind and have a great consideration about the best way to run your office and the way that it works best for you. Just as a couple of points, just to make them very quickly, we are recording this presentation, and we'll provide it later, as well as a PDF of the presentation. We have time for a couple more questions. We're just to get in, but I also understand to put the office on the spot. We'll also have the opportunity to respond to further questions that we don't get to.
Yes.
Great, and so that shouldn't dissuade you from asking any questions while you're still on. I got another one here, a great question. An application fee under LA FOIP, which is the $20, applies to every application made. Does this include minutes, bylaws, and financial statements, tax certificates? Should then the photocopy fees go on top? Diane, I'll refer that to you.
Yes, this is where we have that intersection of different laws and what the requirements are. So the starting point under the Cities Act, Municipalities Act, Northern Municipalities Act, is that it's to be available for open for public inspection. What does that mean? And the ability to charge reasonable fees versus LA FOIP. So I'll let Steven comment on that particular question.
Yes, if it's a document that's set out in, for instance, the Municipalities Act, section, I believe it's 117, off the top of my head, yes. Those sorts of documents, there's a reasonable fee question, and so those are going to be minutes. That's going to be the annual statements and stuff like that, bylaws. That would be potentially where you could consider a photocopy charge. But however, those are publicly accessible things. Nobody should have to request them. And so, again, I will say make it available as much as possible with the lowest cost possible. If you can just post it on your website, that's fantastic. Then that's their charge. They're then having to take any photocopy fees, and they can print off their heart's content without taking your valuable time. Mm-hmm. And so there will be that startup, of course, or maintenance. But overall, it's I think just a good management, which potentially makes your life a lot easier.
And Stephen, a point that I think you made a couple of times, the body that created all municipalities in the province, meaning the Saskatchewan legislature, has had all its proceedings public probably since the beginning. And now it is all online. So in a sense, if the major organization does it, it's kind of a signal to the other organizations it's created, kind of an expectation that at least some minimum documents are available at any time, just to keep our democracy running. Exactly.
And one of the things in the fees, the specific section in the regulation of LA FOIP that speaks to the fees, you don't have to charge photocopying costs because people really do like having electronic or digital records. Is you can charge only what it costs to buy the USB key or the flash drive and charge that back to an applicant and then provide them the 2,000 documents that they requested, and you don't have to go to all that extra effort to photocopy.
Great points, and pretty much just the best way to make things easier for yourself. Let's take a couple more questions, and also for those still on the line, I encourage you, if you can, to stay on and then take a few minutes to fill out a short survey that we have at the end. We always appreciate your feedback and how we can improve our methods and the way that we provide webinars to you. Next question here is, when an employee resigns, it's about their municipal email account. So is that the property of the municipality?
All comes back to records in the possession and control of the local authority. And if it has to do with municipal business, you bet it should remain in the possession and control. Plus, hopefully it's not a personal email account, which again blurs the line. One of the things that we always recommend is that at the onset, when employees are first hired on, that there's some training about what needs to happen with emails, how they need to be saved. Like, do you have every part of a discussion thread? And if you go back over a 2-week period, do you save every single one of those discussions, or is it just the final discussion that gets saved anywhere? But also, usually there's accessible use policies that different organizations have that say, well, you are allowed to do a little personal use with your email or even with the intranet, on your breaks and lunch and what have you. And then it's making sure the employee knows, well, but if you are going to leave us, clean up your email, your personal email. Otherwise, we're going to be sifting through it after the fact, and you may not want us to know about that email that you sent to your mom or your husband or to your best friend.
Great point. Let's go for the last question here. What training is available to become my municipality's privacy expert? Great question. Let's start with you, Diane.
Unfortunately, there's not a lot in the province. We do have a Connections conference coming up in a couple of weeks here in Regina that is being hosted by the Access and Privacy Branch of Justice. There are also some different programs out there. The University of Alberta has a 5-part certificate course on access and privacy that all of the analysts and myself in our office have taken. I found it very valuable. It's not necessarily specific to municipalities, but it's a nice overview in terms of what access and privacy law is all about.
If I could just add to that, I've had a phone call about someone organizing a conference possibly in September in Saskatoon, focused on towns, villages, and municipalities, sort of smaller organizations, and many of whom are covered by LA FOIP. When that gets going between SUMA and ourselves, I'm sure we can let people know that this conference exists. The government also has a 4-part training module online that talks about FOIP, not LA FOIP, but the two statutes are so similar that the principles there would apply. Secondly, sitting back and listening to Diane, this webinar in itself, and Diane giving the bulk of it, is a perfect primer, a good starting point. So that's one thing. And back to the justice modules, I've been lobbying for a conversion of those models to the LA FOIP world. And I know one of these days in Steven's spare time that SUMA will have a great online course. You can see I've been trying to create work for Steven here today, guaranteed long-term employment. So there, and then I'm going to balance it by saying, try to do something once a year to refresh yourself with the basics. But don't try to learn it all and become a master, because depending on the size of your organization, you may only get 1 or 2 access requests a year. So the better thing is, to make note of those resources that Diane referred to, that when you get one, you can go to it. Secondly, get a series of names of people you can call for support. Our office, Steven, government relations, and have those there, because I used to tell a story when I first appointed commissioner. For the first 6 months, I went home exhausted trying to absorb all the rules. Well, if you get 1 or 2 access requests a year, you just don't want to be immersed that much because you have a lot of other duties to do. So try and take in something, whether it's a webinar like this once a year or a conference in Saskatoon or Regina, but just have a list of resources and a list of people you can call when you get the request.
And 2 of the resources on our website that I think you will find the most valuable, one is rules of procedure, so you will know exactly what you're getting into if our office contacts you about a formal process like a review or an investigation, but also a guide to exemptions that was developed on our website. So if you're really confused about, oh no, I think I want to withhold this information, but I'm not sure if I should, if you take a look at the guide to exemptions, it breaks down part 3 of LA FOIP and how do you figure out if something is a mandatory or a discretionary exemption. Perfect example, if you're looking at what's third-party information, you go in there and we talk generally about what that means, but also provide some tests, some questions, some factors to take into consideration so that you can look at the records themselves, and make a more educated decision as to whether or not you really can apply that exemption.
Yes, and the only thing I'll quickly add to that is I encourage you to chat with members, SUMA members. Urban municipalities are the experts in the field. I truly believe that. Just if you have, perhaps there's some that are struggling with that question, but quite frankly, there's a lot that have gone through the issue. And if you know them, then reach out to your colleagues. Also, this obviously will not be the end of our conversation, and education opportunities on privacy and information issues. Stay tuned for future webinars, education sessions, and of course any future articles in the Urban Voice. And we appreciate the opportunity to work with the Privacy Commissioner's Office, because I think that helps show everybody that not only is it possible to move on and work together, but at the same time too that all of these things are possible. Now let's go to the survey, which is up now. Feel free to let us know what you think about this the webinar, as well as perhaps things we can do to improve in the future. We always are happy to hear what you say and act on things where we can. And with that, thank you very much, Ron. Thank you very much, Diane. It was a very great webinar, great information, and a great jump-off point to go to the next stage on all this information. Thank you, everyone, for attending today, and stay tuned for our next webinar on May 14th, where we'll have some speakers from the Ministry of Government Relations talk about the municipal legislative review that's ongoing right now. Thank you, everyone, and have a great day.